What is up? Welcome to the docket, presented by Defense Diaries. I am your host, Bob Mata, and yes, it's me and me alone. Allie might actually jump in. I just misinformed her that the live is supposed to start at 5. As you all know, it's supposed to go down at 4:30. So I'm here, and hopefully Allie will join. Maybe, maybe not. She's really trying to finish that Post-Conviction Relief Act petition, which is moved into the area of nightmare. It really has. It's really gotten to nightmare world with that thing. It's been going on for just about a month. Long hours trying to get that done. Yeah, I mean the thing's like 200 pages long. It's like writing a novel basically. Except you're trying to, win an appeal for somebody and get them a new trial. So the stakes are pretty high with that. But I have been MIA for about a week, I'd say, up until the live this morning. I covered some of the Fani Willis trial or hearing, I should say, to DQ her from Trump's case. It was fascinating, interesting stuff. A lot of lawyers, cross-examining, direct examining lawyers, and a lot of slippery answers. And it was interesting. I wanted to do. I felt bad though. I didn't realize that Jay had a live going at the same time. That I know that I found out after the fact when I got on Twitter. I saw that he was doing something that he was excited about. So hopefully, I'm sure it was a Adelson related thing. So I'm sure he'll pull in a ton on Replay Crew. So if you didn't check that out live, or if you were with me, make sure you go over to Jay and his channel and check out his interview. I think it was with one of Dan Markel's buddies. So I'm sure that had a lot of insight into it. So make sure you go over there and check that out, because I didn't mean to step on my brother's toes. I try to avoid that. I really do, because I love my people, and I'm not trying to overlap them. Like I try to avoid it like the plague. But I've pretty much come to the conclusion that I think it's mandatory that I'm going to have to cover the Karen Reed case. That one requires a lawyer. We're gonna need a lawyer with a live on that thing. So I think I'm gonna do Karen Reed. So I don't know what Jay's gonna do. Hopefully he'll join me a bunch during that, and we could partner up. It's always great when we partner up. I think people dig it. Is my volume low? Is my volume too low? How's that? Tell me, because I'm in my new setup. So this is actually where I record my podcast down here. I'm typically doing my lives upstairs because I've got like my little bedroom set up, but I think it was time to move down here, and the sound should be good because I'm on my real mic and all that good stuff. So, all right, good. I did tweak the gain a little bit though. All right, so I had a death in the family. If you guys are wondering where I was at, my uncle, my ride or die uncle, my uncle Bruce, rest in peace up there, passed away suddenly on Friday. Absolutely took the wind out of me. I was on the way down to actually I had just landed down in Knoxville, Tennessee, and I do this annual trip with my buddies for Super Bowl weekend. There's like 15 of us, and we always gather in different locations and celebrate each other and our friendship, and we watched the game. And I got that a call from my mom that her brother had died suddenly. It was an aneurysm, and he was like my guy, man. Like he was the dude, taught me how to drive, gave me my first car, brought me to more Bears games than I can. I mean, he was really a surrogate father to me. If my dad wasn't around, Bruce was my guy. So it was a gut punch for me. I don't want to try not to start crying here. So that's really why I was staying off for a few days. It's you know how it goes. It's it ebbs and flows. You know what I mean? It ebbs and flows with deaths, with people that we love. So but the memorial or celebration of life is this weekend, so I'm looking forward to celebrating him because he was worth that. All right, enough about me. So while I was gone, the case that never sleeps just keeps on rolling. It just keeps on rolling. Procedurally, it never seems to end in terms of filings. And as you know, I love filings. I am a filing nerd. I'm a law nerd. And I think at this point, I can safely say most of you that hang around with me and Allie are law nerds too. So, which by the way, I'm very proud of. I'm very proud of a lot of you. A lot of you that are members and are subs to the show and come onto the community page. I've been doing um, I've started doing quizzes. Like quiz isn't the right word. I started with a couple of easy questions just to kind of warm you up, and ultimately I ended up really kind of stepping on the gas a little bit. Like the last two questions on our community page were both actually from the multi-state bar exam, which is the multiple choice portion of the bar. Like in Illinois, we have a 2-day bar exam. One is the multi-state where you take a 200 question multiple choice test, and it's general, meaning that it's not specific to the state. It's testing you on general principles of law. Because I have a lot of people in the comments like, hey, blah, 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 blah. I'm like, this is like multi-state stuff. So like, there's going to be jurisdictional differences. And the way that it goes with bar exam, and what's really frustrating is is no wrong answer on the bar exam. Like, so if you get 4 answers, they're all there's no, oh, those 2 are clearly wrong. They're obviously wrong. They give you 4 answers, and what the directions are you are to select the most correct answer, or the most probable answer if it's like a question asking what the probable result would be. And the first one I put out, like stunning, like, and I think over 1,700 people took the quiz. You guys crushed it. It was like 83%. The next one, which I tried to amp it up a little bit, not quite as good. Do better, guys. Nah, I'm kidding. It was tough. It was a tough question. But I'm really trying to teach you guys, like they're all interesting. It lays out hypotheticals, which on YouTube quizzes is very difficult. Like the answers, I only have 80 characters, not words, characters in which to try to cram answers to hypothetical questions in. So it's very challenging for me. Like me actually getting those things prepared for y'all takes more time than anything else I do in my life. No, I'm kidding. That's way, way over dramatized. But so I love that you guys are doing that. You guys seem to really enjoy it. I'm going to keep throwing them out there. I do really I try to impart some knowledge on y'all. I mean that's one of the things that I think that I bring to the true crime community that maybe some other creators don't, and I feel that I do that, and I feel that Allie does that as well, and we really we enjoy the feedback from you guys. It means a lot. There's nothing I love more than seeing those comments that, oh man, I'm learning from you. It's like makes me feel like a nerdy professor, but I love that. Because it's important. And I think overall, the hope is that you guys will end up enjoying what you enjoy to do, which is to consume true crime, content. You love to watch trials. And I think that it's cool to be able to watch it and have a broader understanding of what's going on, So that's kind of what my hope is. And hopefully we give that to you guys all the time. And all right, so back to Delphi. So I think the last couple lives we had done, kind of procedurally where we're at is that, of course, we know that the opinion came out. Of course, we know that Gull had denied their motion for her to DQ herself or recuse herself. That was not unexpected. We all kind of knew that was coming. Then we had a couple more filings. We had uh, kind of the shocker, which I thought it was a shock in the sense that McClellan filed the motion to contempt because to me, when I read it, it was like what they call in the law is res judicata. It's already been decided. Like we heard all those issues. Like I didn't see anything new in the issues in that particular motion for contempt that weren't addressed by the Indiana Supreme Court. So I was a little bit, like I was surprised by it. It just it didn't shock me that they were going to try to take them to a hearing, but I guess that it kind of did, in the sense that it's like there's nothing new there, and I think it's clear from the Supreme Court if she were to remove them again, I think that they just get back on. Like I just that's not an option, and so that and I can't remember the order, and I can't remember if McClellan filed that, and then Rosie and Baldwin filed their motion to dismiss with kind of the stunner that, and I think that came after. I'm sure somebody in the comments will let me know, but that obviously was a pleading wherein they were talking about, hey, all right, we didn't get evidence, and apparently it's been destroyed. Kind of a big deal. Allie and I did a live on that one. Obviously, it is not a good situation for the state. Do I think that there's going to be any long-term ramifications from it? Probably not. I think that what's going to happen will be more of the same, but I think Gull will rely on the fact that the report is going to be sufficient in her eyes. That they talk about Brad Holder had that there was a written kind of a summary of what the interview was, and after that somehow they recorded over the recording on the DVR and lost it. But I think that Gull will find it sufficient. Allie feels the same way. So, like the case isn't going to get dismissed off that, kids. I don't know that you needed me to tell you that, but it's a fact that's not going to happen. So then we had some Good Samaritan defense bar guys once again throw their hat in the ring. And there were a couple of filings, and those are the filings that we're going to go through today. Stevie, if you could pull up, thank you all for your condolences. It really does mean a lot to me. It was a big one for me. But I'm not trying to dwell on it. You know what I mean? All right. So, and Stevie, you're gonna have to scroll because I don't have this up on you're gonna have to scroll as I'm reading. Okay. So we're gonna start with the pleading on the 214, and this was the state's notice and request for discovery cutoff date. And this comes out of the state of Indiana by its prosecuting attorney, Nick McClellan, and respectfully notifies the court that the state has turned over discovery information that the state intends to use at the hearing for contempt in compliance with Indiana Supreme Court rules of criminal procedure 2.5. Previously, Carroll County local court rules, and in support of the following. One, that the state intends to call specific witnesses and introduce various pieces of evidence at the hearing on the contemptuous conduct scheduled for March 18th, 2024 at 9 a.m. in Allen County Superior Court, Courtroom 5. That per local rules and the Indiana rules of criminal procedure, the state of Indiana has turned over a list of witnesses and the list of exhibits to the defense. That the state sent a separate document entitled Witness and Exhibit List to the defense, along with a link that allows them to download the exhibits that the state intends to introduce. That the state believes that the defense intends on introducing affidavits and other exhibits, along with testimony from various witnesses at the hearing on March 18th, 2024. And then finally, paragraph 4, the state would ask the court to issue an order commanding defense to turn over all evidence by 5 p.m. Thursday, March 7th of 2024. And then wherefore the state of Indiana by prosecutor Nick McClellan puts the court on notice that the state has turned over all of the discovery that it intends to use on the March 18th hearing, along with a list of witnesses that it intends to call. The state would further request the defense be ordered to produce all their discovery and witness list for said hearing by the end of business on Thursday the 7th in order to give the state adequate time to prepare for the hearing. So, on its face, that's not, and it's not mind blowing. It's kind of like a boilerplate discovery request. What's interesting about it is that is it how it interplays with the responses to McClellan's motions to contempt. So Stevie, pull up. Can you pull up Mike's the longer of the two responses? Can you do that one first? We'll do Hennessy's second. It's much shorter. Um, but I wanna check out Mike's. Yeah, this is the one. So this particular document dropped. What was that filing date, Steve? Steve, scroll it down a little bit. I think it dropped. So this dropped on the 7th. So that the McClellan thing came after this. So this bad boy, when this came out and I read it, I loved it. It's a beautiful piece of legal writing. Um, it's got a little bit of snark in it, but you can just tell that Michael is a professional writer. He does habeas work. He does what I consider to be the good work. He's in there fighting the fight, trying to right wrongs in terms of wrongful convictions. And the guy's a hell of a writer. So like I just loved this document because when you're reading just profound legal writing, and even if you don't understand like every term within it, when you understand the thrust of it, the concept of it, you know that you're reading something that is well prepared, and that's what this is. So, like, I've been dying to go through this one with you guys because I loved it so much when I read it, and I was DMing Michael, and I'm like, dude, this thing's, and he's a super modest guy, he really is. And I was like, dude, you got to come on the live, and he's like, oh yeah, he really likes to spread his like whatever glory he may get. He likes to spread it to his students. He really does. He likes for them to kind of get the glory. Like he's just a very modest, exceptionally bright guy. So let's go through this thing. And this is in direct response to McClellan's motion for contempt. Okay. So defendant counsel's motion for summary denial of the state's verified information for contemptuous conduct. Counsel for defendant Richard Allen, Andrew Baldwin, and Bradley Rosie by counsel now come before the court with their motion for summary denial of the state's verified information for contemptuous conduct, herein after going to be referred to as information, filed on January 29th, 2024, for the reasons that follow. The court should summarily deny the state's information, period. Introduction. The state's information has many flaws. Not least among them is its failure to allege, either directly or by inference, either Mr. Baldwin or Mr. Rosie committed any of the supposed offending acts willfully. See Indiana Code 34-47-3-1, which defines indirect contempt as willful disobedience, and that's in quotes, of a court order. But the state's information has two additional flaws that are fatal. First, to the extent that the state's information purports to allege indirect civil contempt, it fails to allege any act injuring the state that a remedial or coercive contempt sanction could redress. The state therefore lacks standing to pursue its information. Well, is that right, Stevie? as one for indirect civil contempt, and this court lacks jurisdiction to consider it. Second, because there is no available remedial or coercive contempt sanction, any contempt sanction would necessarily be punitive and therefore for a finding of indirect criminal contempt. But to pursue indirect criminal contempt against Messrs. Baldwin and Rosie, the state would have to file its information in a separate criminal case. All right. So if you guys, so what he is saying, and it was the same question that I was pondering. So I was so thrilled when he came forward with this, and I was so thrilled, frankly, that he had gotten involved with it. So indirect civil contempt, just so you guys, and I think that I kind of went through it when we had our first live, but just kind of a refresher. Essentially, what happens with that is there's court orders. Like, this is your most basic description of it. You have a court order in place, and somebody outside of court violates the court order, and they do it willfully. So because it happened outside of the confines of the courtroom, they consider that to be indirect civil contempt, but it has to be willful, meaning, like the easiest example is child support. Okay, so when somebody has a child support order in place and dad is not paying or mom is not paying, and then in Illinois we call it a rule to show cause. We file a motion for a rule, and basically we were asking the court to hold that person in contempt of court, indirect civil contempt, for violating the court order willfully. Now, they're not paying the support. They know that there's a court order in place. They know that they are court ordered to pay it, and they're not doing it. So we go through that whole process, and there ultimately is a hearing. We have to show that it was willful, which can get sticky. If dad lost his job or mom lost her job, and they're not paying it because they don't have the money, is that willful? Well, I don't know, but are they trying not to get employed? You'd be surprised how spiteful people can be about paying support because they feel like the other spouse is just using to get their hair did, or whatever the case may be. It's like I for 20 years I heard all these stories, and I'm like, just got to support your kids, man. But at the end of the day, ultimately, that's kind of a nutshell of what indirect civil contempt is. It's the easiest way to do it. So what is being said here is that there has been, in the entire document that was prepared by McClellan, there was no indication of anything that was contained within that document being done willfully. Okay, meaning, like, they would have to come to court. They will have to come. McClellan will have to come to court with some kind of proof that Baldwin intentionally allowed Mitch Westerman to leak the crime scene photos. Like, in my that's my, like, that would be willful. Like, if he has proof that for some godforsaken reason Brad allowed, or that Andy allowed for that to happen, and or orchestrated it, then he'd have a case for you know willfulness, because otherwise, him not locking the door and a guy coming in that he trusted and taking it upon himself to get pictures and then spread them around without his knowledge is not willful. It's just not what willful is. So, short of that, and McClellan didn't make those allegations in his motion. But beyond that, I just do not believe that Andrew Baldwin would do that. It doesn't benefit the defense. In no world does that benefit the defense. Anytime crime scene photos are at issue, primarily a trial, it, we fight like hell to keep them out. Like that, it's just, we really, really, really fight like hell to keep it out. And because all it does is, like, they inflame the jury. They get the jury reacting from a place of emotion as opposed to a place of logic. And that's the last thing that we want. From the defense side of it, if the jury starts coming from a place of emotion as opposed to relying on the evidence, the facts, and the law, we're going to be doomed, especially in a situation where you have two young girls, or any child, or anybody really, that has lost their lives, that it changes the game. So we never want the jury being pounded over the head with these photographs because it just upsets the jury. And it becomes, well, somebody's paying for this thing. Oh, well, it's going to be the guy sitting at the table. So there was no evidence of that in that pleading. That's what he's saying here. And as far as criminal contempt, what he's saying is that in order for it to have been indirect criminal contempt pursuant to the law in Indiana, he would have had to have filed it under a separate case number. It wouldn't be in Richard Allen's case. It would have to be filed as a separate action, and it wasn't done. He just filed it in this case. So let's keep going through. He breaks it down beautifully. Okay, so information in a separate case. It has not done so. And this court has no authority to punish Messrs. Baldwin and Rosie for indirect criminal contempt in this criminal case against Mr. Allen. And then he's got footnote 1. This is the written motion required by Indiana OA2A, which provides in relevant part no petition for a writ of mandamus or prohibition will be entertained unless the relator has raised the jurisdictional question by written motion which the trial court has denied or not ruled upon timely. The motion shall allege the absence of jurisdiction of the respondent court or the failure of the respondent court to act when it was under a duty to act. All right. Now we're going back up to the body. Finally, were the court to impose without jurisdiction or authority to do so any necessary punitive sanction on the state's information in this criminal case against Mr. Allen, it would be at least the second time the court has interfered with Mr. Allen's 6th and 14th Amendment rights to counsel. See Strickland v. Washington, an 84 case. The court has considered 6th Amendment claims based on state interference with the ability of counsel to render effective assistance to the accused. All right, and that's got footnote 2. At least one other time, of course, was when on October 12th, 2023, in an email that the court ordered Messrs. Baldwin and Rosie to stop their work on Mr. Allen's behalf for at least a week. State interference with counsel in violation of the 6th Amendment is a structural error for which prejudice is presumed. And that's Weaver v. Mass. And then he cites Strickland again. Government violates the right to effective assistance when it interferes in certain ways with the ability of counsel to make independent decisions about how to conduct the defense. And that's actually citing Getters or Getters. Amendment right to counsel violated without showing of prejudice for the trial judge's interference with defendant's right to counsel, to consult with counsel, notwithstanding so-called Younger abstention, because it may well not apply. See generally Younger v. Harris, which is a 71 case. Further, state interference with his lawyers could well compel Mr. Allen to seek federal habeas relief under 28 U.S.C. 2241 C3 in the form of an injunction. Were Mr. Allen to prevail in that undertaking, a conditional writ of habeas corpus through using more formal legal, go up, Stevie, to the bottom, to the rest of the bottom of that page. There you go. Language would look something like, quote, release Mr. Allen or leave his lawyers alone. See, there's that snark. Like the way I love it, the reason that I love it is not because it's snarky alone, but because it just puts it in layman terms. I mean, like that's what it would read like. So release Mr. Allen or leave his lawyers alone. But win or lose, federal court is not a railroad siding Chief Justice Rush likely had in mind when she said at the hearing on the second original action involving this court in this case, quote, my concern is getting the case back on track. And then he cites the hearing. All right, go back up, Steve. You're doing great, Stevie, by the way. All right, so now he's going to break down the arguments. Okay, the state's information has not alleged an injury a civil contempt sanction can remedy. The state therefore lacks standing to pursue its information as one for civil contempt, and this court lacks jurisdiction to consider it. A, the state's information attempts to allege Messrs. Baldwin and Rosie committed acts of indirect contempt. As a matter of law, almost older than dirt. Everyone loved that. The meme started coming up with that. It was great. When I read it, I loved it too. There are two kinds of contempt: direct and indirect. Contempt of court generally involves disobedience of a court or a court order that, quote, undermines the court's authority, justice, and dignity. Uh, there are two kinds of contempt: direct contempt and indirect contempt. Indirect contempt, which is at issue in this case, involves those acts which, quote, committed outside the presence of the court, which nevertheless tend to interrupt, obstruct, embarrass, or prevent the due administration of justice, end quote. Um, and then Reynolds v. Reynolds. Uh, so he cited both the Encyclopedia of Contempt and then a case. All right. And then it should not matter. It should not be a matter of dispute that the state's information at least attempts to allege Messrs. Baldwin and Rosie committed indirect contempt. None of the acts that the state's information alleges were contemptuous occurred in the court's presence or about which the court itself has knowledge. See in Ray Nasser. Direct contempt depends on, quote, the judge possessing personal knowledge of the contemptuous act, citing Hopping v. State. All right, we're on 4. Okay. Sanctions for indirect civil contempt must be remedial or coercive for the benefit of an aggrieved party. Sanctions for indirect criminal contempt are punitive. As a second matter of law, almost older than dirt, direct and indirect contempt each come in two varieties: civil and criminal. Sanctions for civil contempt are for, quote, the benefit of the party who has been injured or damaged by the failure of another to conform to a court order issued for the private benefit of the aggrieved party. Now, the child support order is a perfect example of what he's talking about here. The aggrieved party is the parent that's not receiving the support. The order was put in place for the private benefit of that aggrieved party. All right. So, and then he cites some cases. Sanctions for civil contempt also must be either remedial or coercive. Okay. The object of a civil contempt, of a civil contempt, is the enforcement or protection of the rights of the complainant, and only a coercive or remedial judgment may be entered. Federal authority is no different. For civil contempt, the punishment is remedial, and the benefit of the complainant on cert to the district court. Move up, Stevie. Please and thank you. For the district court. Oh, did you move up too far? I don't know. Come down a little bit. Of appeals. Okay. And on cert to the Virginia Supreme Court. So he cites the cases. Criminal contempt, on the other hand, is, quote, an act directed against the dignity and authority of the court, which obstructs the administration of justice and which tends to bring the court into disrepute or disrespect. Sanctions for criminal contempt are intended to vindicate the authority of a court. So he's giving you the differences there between civil and criminal. All right, go down. C, the state's information alleges no injury a civil contempt sanction can meaningfully redress, and the state's resulting lack of standing to pursue its information means the court has no jurisdiction to consider it. Even were the court to take as true every allegation of the state's information, no sanction imposed for any of the alleged contemptuous acts would remedy an injury to the state, nor would it coerce Messrs. Baldwin and Rosie to comply with any order of the court. The state's information of the court that the state's information alleges they violated. And then he cites the code. Okay, the court shall, on proper showing, extend the time provided under subsection B3 to give the defendant a reasonable and just opportunity to be purged of the contempt. Okay, now what he's talking about with purge, and again, like the easiest way to do that is take it out of the criminal realm and put it in the civil realm. And again, like, so if I go in and I had a client that was either, if I'm repping the parent who's the aggrieved or the one who hasn't gotten the money the support or the one who owes it. If I'm representing the aggrieved, I'm saying, okay, well, we want a lump sum. Like we've proven that they have money. We've gotten into their bank account. We know they have their $7,000 in arrears, and we're asking for a lump sum. And so what typically will happen is that the judge will say, okay, I'm finding you in contempt. And in our county, what they do a lot of time just to put the fear of God into the defendant is like, I'm going to sentence you to 30 days in jail, which is really the only kind of debtor's prison they have, which is for support or these contempt charges. But I'm going to stay it, meaning I'm not going to put you in jail right away. I'm going to stay it for 30 days, and I'm going to set a purge amount of $5,000. So if you can come up with the $5,000 before that 30 days comes and goes, you don't have to go to jail. And that's what they call a purge. They call that like that. I'm going to set the purge amount at 5 grand. So same concept here. And what Michael's saying here is that that's not available. Like there is no agree. Like we can't there is no unleaking the discovery. There is no unfiling the filings that they find so offensive. So like those things there is no remedy under the law for them. All right. Okay, the state therefore has no standing to pursue its information. Quote, the standing requirement is a limit on the court's jurisdiction, which restrains the judiciary to resolving real controversies in which the complaining party has a demonstrable injury. Cite some cases. Okay, only those persons who have a personal stake in the outcome of the litigation and who show that they have suffered or were in immediate danger of suffering a direct injury as a result of the complaint of conduct will be found to have standing. Cites case. Absent this showing, complaints may not invoke the jurisdiction of the court. Cites a case. The reason I say cites a case because he's putting his argument together by plucking the language out, which is what proper, beautiful legal writing does. It pulls language from precedent, from states, from cases that have that are going to hold weight with the court. They're all Indiana cases, so these are the cases you want to cite. And he builds his argument by using the language from different cases that support his position. That's when you're reading a legal argument. That's what you want to see. You want to see all of the precedent that's binding on the court used and plugged into the argument. And he actually forms the argument by using quotes, holdings from different cases, and creates the argument. It really is a great document to read if you're a lawyer. Even if you're not, it's a well-written document. So without an injury meaningfully redressable by a civil contempt sanction, the state simply does not have standing to pursue its information, and this court does not have jurisdiction to consider it. Miller cites Miller again, because Miller did not have standing to bring his contempt motion. The trial court did not have jurisdiction and should have dismissed the motion. Accordingly, the court should summarily deny the state's information. And then paragraph 2, the state's information can only be seeking punitive sanctions for criminal contempt. So what he's done is he's made it clear that the indirect civil contempt, you can't even move forward on it. Like there is no remedy under the law that's available to McClelland under an indirect civil contempt. It just doesn't exist for him for all the reasons that he said, but primarily the thrust of the argument, there's no way to redress it. Like, and just think of it in terms of you really can't unleak the leak. That's the cat's out of the bag. That's done. So he then switches to now attack the concept of criminal contempt. So the state's information can only be seeking punitive sanctions for criminal contempt. The state filed it in the wrong place, and the court has no authority to impose a criminal sanction in this criminal case against Mr. Allen. without an available remedial or coercive sanction. Any sanction imposed by the court, whether imprisonment or a fine, would be punitive, thus making the object of the state's information a finding of indirect criminal contempt. So now he's placed it that this is what it is. So everybody that was asking, well, is this indirect civil contempt? Is it criminal contempt? He's broken it down for us. So now he's saying, okay, well, this is what it is. And now we're going to see if he thinks that it's applicable or that it has legs. All right. So is a third matter of law, almost older than dirt. Quote, a fixed sentence of imprisonment is punitive and criminal if it is imposed retrospectively for a completed act of disobedience, such that the contemptor cannot avoid or abbreviate the confinement through later compliance. And that's Bagwell. That's a U.S. Supreme Court case. Similarly, a flat, unconditional fine totaling even as little as $50 announced after a finding of contempt is criminal if the contemptor has no subsequent opportunity to reduce or avoid the fine through compliance. Cites Bagwell again, cleaned up. B, an information for indirect civil contempt must be filed in a separate criminal action. As a fourth matter of law, almost older than dirt, if the state, by its information, is seeking punitive sanctions for indirect criminal contempt, it filed its information in the wrong place. A proceeding for indirect criminal contempt must, quote, be filed as an independent action, and end quote, and must also be prosecuted by the state, quote, end quote. William Hensel and Mark Kiesling were charged with indirect contempt of court and an information filed by the Lake County prosecutor. Stevie, I'm on page 7 down there at the bottom. Wait, go up or go back down or up just a hair. Let me. Here, go up. Yeah, just go up a little bit. Or is this the beginning of that paragraph? Sorry, y'all. It's a little clunky. It's our first time with Stevie, like scanning through my doc. All right, go back down. Go back down. Yeah, I'm going to have to retake control of the documents. It's too much for Stevie. I think I'm probably going to give him some kind of I don't know what'll happen, but it can't be good. And an information filed by the Lake County prosecutor. A criminal charge, a charge of criminal contempt should be prosecuted by the state against the defendant in an independent action, Denny v. State. The information for a criminal contempt should be entitled State of Indiana versus Defendant and filed as an independent action and prosecuted by the state. So now he's just citing cases where it's telling you, look, if you're bringing a criminal contempt action, it's got to be under its own case number. Like you're not bringing it in Richard Allen's case because it's a separate action. So in a separate action, the state charged Jones with indirect contempt under the Indiana Code section 3447-3-1 and 3447-3-5 for her failure to appear at October 7th deposition. C. So that's clear. So like it's going to be interesting to see what Gull's going to do with this. It's very clear to me that he's right on the law, and it's clear to me that the only avenue that McClelland has is a criminal contempt action. He filed it in the wrong place, and like he hasn't tried to fix the issue. Like he's had this now since February 7th, and he's done nothing to try to fix the issue, which is interesting. You know, it's like, I mean, no one likes to be pantsed, publicly. I mean, and if you're just kind of looking at it, and I'm not trying to pick on McClelland, but in terms of the law, I just imagine that Nick McClelland has never had to file anything like this in a case before. This is all new territory, not just for McClelland, for a bunch of these guys. Like, I don't know that anybody's gone through anything like this in a criminal case where you have so much collateral stuff happening, collateral to the underlying trial, like this is all new territory, you know, but at some point he's going to have to sack up, or Gull's just going to have to deny it on its face. She's going to have to grant what he's asking for here. All right. So C, the court has no authority to impose any punitive sanctions for indirect criminal contempt in this case, in this criminal case against Allen. The court simply may not impose any punitive sanction for what could only be a finding of criminal contempt in this criminal case against Mr. Allen. That would amount to a conviction and punishment on a charge the state has not made. I want to read that again. The court simply may not impose any punitive sanction for what could only be a finding of criminal contempt in this criminal case against Mr. Allen. That would amount against Mr. Allen, not against Baldwin and Rosie. Allen's the defendant in this case. You guys getting that? He's the defendant. Rosie and Baldwin aren't the defendants. That would amount to a conviction and punishment on a charge the state has not made. Okay. So the situation would be no different from than in McMinn. McMinn was convicted on a charge not made, which is, of course, a sheer denial of due process. And cites De Jong. And then, therefore, the judgment and commitment issued thereon are void. And that's another Supreme Court case, Johnson v. Zerbst. And then, accordingly, for the second reason, the court should summarily deny the state's information. Wait, I missed that. Go up. So well, I'm just going to read this footnote. I didn't catch it. I missed it when I was reading. Okay, so I'm assuming that it was under probably this last argument. Not only was the state's information filed in the wrong place, but as written, it also fails to make out a criminal charge. It does not allege Messrs. Baldwin and Rosie acted willfully, omitting a material element of indirect contempt. This is not remedied by any reference in the information to Section 3447-3-1, which defines indirect contempt as willful disobedience of a court order. Conclusion. For the foregoing reasons, Messrs. Baldwin and Rosie respectfully request the court summarily deny the state's verified information for contemptuous conduct. So there it is. So, and there, Michael Osbrook did a beautiful job with it. I mean, like, it's just clear. Like, even if you don't understand all of the language, because there's a fair bit of legalese in there, he makes it clear as to what the concept is. And the concepts are pretty simple. One, the underlying concept is that there is no willfulness as to anything he alleged in his motion at all. Doesn't exist. Which is what I was saying all along. And I was thankful because I don't practice in Indiana, and I didn't know whether this sounded in civil or criminal contempt out there, and, the people were trying to guess, well, he's asking for potential jail time, so maybe it's sounding in criminal. What I wish I had Michael on to ask him was, as it stands right now, as it currently stands right now, and we know because we just read McClellan's motion for reciprocal discovery, do Baldwin and Rosie, do they have a duty of reciprocal discovery in this case? I don't see how they do. But maybe I'm wrong. Like in Illinois, there would not be reciprocal discovery. I would not have to give the other party discovery in the matter. It's their motion for contempt. But I don't know. It's interesting. All right, so pull up the chat, Steve. Let me see what's going on in there. Um, so that's to me, that's clear cut, you know. And I don't know if it's clear cut because I'm biased or if it's just really well done. I think it's more along the lines. It's a really clear and concise argument, and I just can't see a rebuttal to it. Does that mean that the state's not going to file? Of course they're going to file. I mean, they'll file something, but I mean, the law is the law, and on this one, it seems pretty clear. Aside from it being race judicata, which again, I mean, we've gone through this. We've done this already. I mean, at this point, the people who hate the defense and think that Baldwin and Rosie are clowns and like to, like blame them for everything. This one's on Nick, right? I mean, we're trying to get this thing back on track, and he's filing this thing. To what end? I mean, if there's one thing that's evident from this, it's that there is no end. There's no end game for McClelland on this thing. You know, I mean, it's just that there is like it's not going to end up with them being removed again unless Gull is going to improperly remove them again. I mean, that's the only way it can happen. Hold on, me. Did you play that, Stevie? In my headphones, it was terrifying that little noise. All right. Okay. Let's go to Hennessy's thing now. It's much shorter. And Hennessy was looking for some clarification. Like Hennessy was kind of asking exactly what I was asking with regards to what is this that you filed, Nick? Inquiring minds want to know. All right, so give us a second while Nick's going to pull that guy up. Oh, look at him. The guy's a champion, man. All right, so this thing was filed. It looks like here, move it down a hair. I can't see it's right under that live or up. I always say the opposite of what it's supposed to be. All right, whatever. It looks like it was filed, I think, a couple days before Michael's was filed. All right. So this is a petition for clarification regarding contempt hearing, and this one was filed by Hennessy. So David Hennessy's back. And I believe that Hennessy's going to be the one handling the actual hearing. Like he's going to be the one putting Andy on the stand and potentially Brad as well. Because I don't think Michael's going to be doing. I mean, if she's going to require some kind of argument, which I can't imagine that she will. Like, I don't know why all of a sudden she decided, like, if ever there was a motion that could be decided on the paper alone, it's Michael's. Like that one doesn't require a hearing. It's the law. The law is clear. She's going to have to she should have been like if she was being just normal, like Gull would have already said, yeah, Nick, sorry, dude. You dropped the ball on that one. It's not the right thing. Like if you want to try to come back with a criminal contempt, then file it proper. But she's just sitting there on it. Not only is she sitting there on it, she made a date knowing that Michael's document was out there. Whether did she read it? I don't know. She might not have read it. It's possible she didn't read it. All right, so okay, we've got come now. Attorneys Baldwin and Rosie by counsel respectfully petition this court to provide clarification regarding the March 18th, 2024 contempt hearing. In support of the request, counsel state that on January 29th, 2024, the state filed what it titled verified information of contemptuous conduct. Paragraph 2, on February 1st, 2024, the court set that pleading for a hearing on February 12th, 2024, which was then continued to March 18th, 2024. Paragraph 3, attorneys Baldwin and Rosie are without sufficient notice as to the details of the state's allegations and how or why any specific acts are alleged to have been contemptuous. Paragraph 4, the state referenced the following with insufficiencies described. A, It refers to a press release issued prior to any quote gag order, end quote, without specifying how or why that was contemptuous. B, that Mr. Baldwin failed to disclose an accidentally misdirected email, but cite no authority or order requiring disclosure. And I just want to say, um, I listened to the Murder Sheets most recent thing and episode, and they keep misstating that email being sent by Brad Rosie. I just want to be clear that the missent email to the former client was accidentally done by Baldwin, not Rosie. It's the second time I've heard them do that. I just wanted to be clear which lawyer did that, because it was always my thing with Rosie. I'm like, well, what allegations did they have against Brad at all? I didn't have an understanding of why they were lumping them together as if they're, Siamese twins working from the same body with two different heads. I mean, they're not. They have separate practices, they have separate offices. So I just wanted to clarify that. It had kind of gotten under my skin. Like the first time I'm like, okay, but then it happened again in their most recent episode. So I just wanted to be clear in case people are thinking that Rosie is the one who accidentally sent the email out to Woodhouse, because it was Andy. And I don't, man, I've done it. It's like, and it's like, I always have language. I'm like, look, if you get this in error, I'm asking you not to read it. And, and just realize it's a legal document. Please don't read it. It was sent in error, and like, I mean, I'm sure he has that language on there. It clearly he wasn't sending a former client intentionally any kind of documentation relating to, the discovery in the case. I mean, even the concept of him to like that, this is so petty to me that they keep bringing that thing up. It's like, it's just petty. It just is. And if you want to call it sloppy, maybe, I guess, not really. I mean, I just like, it's probably because I'm old. I've had that auto populating thing happen to me before, where I'm just making assumptions and it auto populates. I don't double check it, and I click send. And then I'm like, oh my God. Or I'm not like, oh my God. And I get a return email like, I don't think this was meant for me. I mean, it happens. It's an honest mistake, period. All right. C, referenced the Frank's memorandum as having graphic descriptions and defense created demonstrative exhibits, but again, fail to advise how that was contemptuous conduct. D, reference Mr. Westerman's unauthorized photographing of discovery, but fail to allege how that was the fault of Mr. Baldwin or Mr. Rosie, or how it was willful conduct on their part. E, Mr. Baldwin brainstorming with Westerman, violating both orders, but ignore that in an in-chambers meeting, brainstorming and strategizing with persons not on the defense team was declared permissible. F, allege a trend of Baldwin and Rosie not being completely honest, yet offer no details or cite to any authority or requirement to support the allegation. 5, it seems clear that the state is really attempting to charge indirect criminal contempt. See defendant's counsel motion for summary denial of the state's verified information for contemptuous conduct. As such, a separate filing and initial hearing would be contemplated. 6, attorneys Baldwin and Rosie respectfully request notice whether the March 18th, 2024 hearing will be a formal advisement of the specific allegations, or whether the court anticipates hearing testimony and receiving evidence. So what he's asking for there is that going to be the actual hearing date? That's the thing with Gull. Like they still don't know. Is that the date that we're going to hearing, where we're putting the witnesses on, or are we just coming in? Because in my state, you have to issue what they call a rule to show cause has to be issued. Now, I don't know if anybody in the chat from Indy. I don't know, maybe Michael's even in here. I don't know if they issue rules there. Like here, they issue a rule to show cause, and you're given notice. So, like, it's a legitimate question by Hennessy. Like, what what the hell's going on the 18th? Are we having the hearing, or are you just going to tell us what's what? You know, um, so and then wherefore Baldwin and Rosie respectfully pray the court to provide guidance as to the substance of March 18th, 2024 contempt hearing that is scheduled. So, I mean, there you go. Once again, it's just lawyers should not be having to guess what upcoming hearings are, and that goes for both sides. Like unless she's having discussions with McClelland, um, Sands, Baldwin, and Rosie, which is not allowed. Um, like how like McClelland can't know either. It's like he filed this thing, and he's got to be sitting there. He reads Osbrook's thing. He's like, okay, seems like maybe I fucked up. I don't know. Hey, Luttrell, did I fuck up? You might have there, Nick. But still, so Gull creates a date for it, but doesn't say what the date's for. Like no one knows. Like, just tell the attorneys what is going on. It's not too much to ask. Just quit doing this. Like, seriously. Like, again, like I don't even want to read her court orders. I'm like over her. Like, just act like a judge, for God's sake. Like get over yourself. Like is this still like some kind of weird pissing match? Like, just do your job. Do your job. All right, enough. All right, so Stevie, what else was filed? There was something else that was filed. It was brief. Oh, like, we don't even need to read the motion. I know that yesterday, the day before, that it was interesting. If I sent it, it was the motion for cameras in the courtroom. So the defense, interestingly, uh, again, filed to have motions for cameras in the courtroom for the hearing on the 18th. Oh, there it is. What a guy. What a guy. So yeah, oh no, that's a different one. That's not it. You don't even have to pull it. I might not have even sent it to you unless I should have just forwarded you the whole thing from the clerk. So basically, they want cameras in there on the 18th. The defense does, um, which I found to be fantastic. It's like they're basically saying, like, we've got nothing to hide. I mean, everybody knows what you're alleging we did. So let's do it out in the sunlight. Let's just have at it. Let's go. Let's see what's what. Um, so additionally, what I did see um today, in the case that never sleeps, I was upstairs, and I'm like, wow, there was nothing, like, no orders, nothing was filed, clean day. And then there were some filings. This time they were the defense sent out 4 uh subpoenas duces tecum, which are asking for documents. So they're pretty interesting. So they're trying to get some documentation, and I'll just read it to you from here. They filed 4 today. Request for, wait, is today the 17th? It might have been filed. Today is today. Oh yeah, today. All right. So they filed a request for subpoena duces tecum for one Sergeant Jerry Holman. They filed a subpoena for one Detective Ben Rector of the Indiana State Police. They filed a subpoena for one Stephen Mullen from the Carroll County Police. I'm assuming police, PO, Carroll County Sheriff's Department. Carroll County police officer. I don't know what it is. It seems like does Carroll County have its own police? It's gotta be yeah, they must. I think so. All right. And then finally, interestingly, a subpoena, Deuces take him for Mitch Westerman. So, and they're asking for documents from all those individuals. And when you're filing the subpoenas in court, so those are out there, and they're they're rooting around for something, because at this point we know that the defense has everything that McClellan's going to put out there. All right, and we also know that um, these guys are like, I mean, they're preparing to go to hearing. I mean, they're asking, what this thing is going to be on the 18th, but they're preparing as if it's going, which they should. Like, we don't want this to be another situation where everybody's say, "Well, you had notice. She told you there was like going to be a hearing, even though it wasn't specific." I just, the question then becomes, how does she go to hearing on either indirect civil or indirect criminal contempt if she doesn't have the ability to do so? Like, is she just going to disregard the law? Like, especially with the criminal contempt thing, because it seems that that's what it has to be. So she's going to like completely ignore the law and conduct the hearing under Richard Allen's case number. I mean, I just want you to understand, like, Baldwin and Rosie are not defendants in the case. It's, yeah, I don't know. I don't know what she's gonna do. It's like everything that she does is just like makes me scratch my head. And I'm not trying to pick on her. I'm really not. She's just doing a shit job. Period. Like, and if you know anything about the judicial system or the criminal justice system, eh, you have to know that. You have to know that. Like, if you're, if you're one of the big, we want justice for Abby and Libby folks, and you hate the defense and everything like that, and you're not calling her out for the shit that she's doing now, I have a hard time believing that your interests are pure, because like it is what it is. She is not doing the job. And when she does do the job, she does it improperly. And I don't understand why. I mean, she's been doing this a long time. I know she knows better. She has to. She's been doing it too long, you know? So, how it's gonna play out on the 18th, I don't know. I'm gonna be there. It'll probably be one of the things where, she's gonna just give a date for the real hearing, and I'll have, wasted 5 hours of my time driving there. But I'm gonna do it in the event that it turns out to be a showdown, you know? So the one thing that I haven't really been able to talk about much, is like what, so I've been saying and wondering when they were going to file, they being Baldwin and Rosie. And I said it when we did the live regarding the motion to dismiss, where it became evident, based on their allegations and their motion, that Nick McClelland had accessed attorney work product between Westerman and Baldwin on a case that he's not prosecuting, on a case that doesn't take place in his county, and he's got no business looking at Baldwin's attorney work product at all. It's verboten. It's not discoverable. Like, attorney work product is theories, strategies, things you can write it. It could be on a napkin, whatever. Conversations that you have with people, strategizing. If he's doing that via text, and so McClelland makes this admission in that thing. So I've been waiting and waiting and waiting for them to file. And I think that I've come to the answer. And I think that the answer is that they're going to wait until after this hearing so that it's on the record. so that they get McClelland on the record stating that for some reason, reasons unknown, he felt that it was okay for him to read messages from Andrew Baldwin to anybody. But at this point, he knew that the messages to Westerman were probably relating to strategy because of everything that preceded it. Like McClelland's been bitching about him talking strategy with Westerman since this whole leak thing started. So he can't turn around now and say, well, I didn't know. Yeah, you did know because you put it in your pleadings. You've been sniveling about it for months, as if it's wrong for attorneys to discuss strategy with other lawyers or non-lawyers. I do it all the time. All the time. There is nothing wrong with discussing trial strategy with anyone. And beyond that, they got approval from the judge. So, in terms of when I think that's going to come down, because I think it's going to come down. I think it has to come down because if he has, and it's not like a motion to DQ him, it's a motion to appoint a special prosecutor, just pluck him out, and they get a special prosecutor to handle the case. Stevie, is that something you want me to read? Why you popping that up? Bob, footnote 1 on first document. Read it, please. Most important. Thanks, Bob. All right. Let's see. I think I did read that. I'm pretty sure I did, but I'll read it again. Joanne, were you late? Let's see. Okay. Okay, footnote 1. This is the written motion required by Indiana Original Action 2A, which provides, in relevant part, no petition for a writ of mandamus or prohibition will be entertained unless the relator has raised the jurisdictional question by written motion, which the trial court has denied or not ruled upon timely. The motion shall allege the absence of jurisdiction of the respondent court or the failure of the respondent court to act when it was under a duty. All right. So there's that. It is important. I mean, like, essentially what they're saying is, look, if this thing goes in front of the Indiana Supreme Court again, they're not going to be happy. They're just not going to be happy. So I don't, I don't know what Gull's doing. I honestly don't. It's like, so it really is, it's hard to try to wrap your mind around it, to be honest with you. I just don't I don't know what she's doing. I don't know. Like, if she's gonna be on the case, then fine. But but do it proper. Just like with whatever's past is prologue, let's move forward. Let's just start handling it like a normal case. Let's just set hearings, have hearings, like, just, if you want to deny things, fine, give a written order as to why you denied it, maybe cite some case law, maybe cite the right, standard or burden, and then, like, we'll move on. It's like I spent my life losing motions constantly. I mean, defense attorneys lose motions constantly. It's not unusual. I'm not sweating her for denying motions at all. I've said this before. I'm sweating her because she's not doing the job. And anybody who knows anything about the criminal justice system, if they think that she's doing the job, I'm willing to debate you here. You just let me know. I'm not going to debate anybody who doesn't know anything about practicing law. But if you practice law and you want to debate me that she's doing a fine job on this case, I'm here for it. I'm here for it because I'd love to hear it. I'd love to hear what you have to say in terms of her doing a good job on this case. It's a nightmare. I mean, coming out of the Supreme Court thing, like, all of us had to think, all right, Finally, we're getting on track. We're getting closer to this trial thing. Are they going to file the 70-day? Are they going to file the 70-day? Is this trial actually going to happen before October? Like, does that even seem possible? Like, they're filing bullshit. They're filing this thing, which is now dragged it to March 18th is where we're at. Why do you keep is that footnote 1 again? I'm not reading again. It's been read. Is that why you pulled it up again, Stevie? I'm missing it. Like, is there, like, something in the chat that I'm missing about footnote 1? Oh, man. Oh, we had another amazing, gifting 50 memberships. Wow. Well, I'm definitely gonna give the love at the end here, which I'm getting close to wrapping it anyway. Um, Look, y'all, I read all the footnotes, you guys. Did you not hear me? I read every single footnote, and I read footnote 1 twice. Twice. Can I get a witness? I did not miss any of the footnotes. I was reading every footnote, right? You guys remember me reading them? Can I get a witness? Somebody give me a witness. Somebody be a witness. I 100% read footnote 1. Were y'all late to the thing? Is that what happened? Because I can go back. This is recorded, and I'm gonna watch myself reading footnote 1. Do you guys don't want me to read it again, do you? A third time? Is that what you guys want me to do? Can I get a witness? Yeah, I definitely read it. But I like now at this point, I've read it twice. Do y'all want me to read it again? I will definitely read it again. Y'all are the boss. If you guys want me to read the footnote again, I am way late to that. Like, I can't have the chat up because I had to have the document up because I'm letting Stevie do it. Like, next time I'm going to put it back on my screen. I like it better. I like controlling when the way I'm reading it. Um, Even though I like that Stevie's able to throw it up there for me. It's just tough for him too, for him trying to keep along because he's probably trying to keep an eye on the chat. All right, so what is the verdict, y'all? Do they want me to read footnotes again? All right, footnote 2. Bring up footnote 2 again. Let's read footnote 2. I definitely read all the footnotes, y'all. I feel like I'm being gaslit right now. All right, footnote 2. Yeah, I 100% read this. Y'all weren't paying attention is what was going on. All right, at least one other time, of course, when on October 12th, 2023, in an email, the court ordered Messrs. Baldwin and Rosie to stop their work on Mr. Allen's behalf for at least a week. State interference with counsel in violation of the Sixth Amendment is structural error for which prejudice is presumed. Weaver v. Mass, and that's a 2017 case. See also Strickland, and that government violates the right to effective assistance when it interferes in certain ways with the ability of counsel to make independent decisions about how to conduct the defense. And that's Getters or Getters. So, and that's a big one because like that's not even just like I like everything that she's done I've seen is not just her saying stop working, but her in her own subjective opinion not liking the defense they were putting forward. That's the way that I felt about it. And I think that particular citation goes directly to that. The Sixth Amendment right to counsel violated without showing of prejudice for trial judges' interference with defendants' right to consult with counsel. All right, notwithstanding so-called Younger abstention, because it may well not apply. See generally Younger v. Harris, a 71 case. Further, state interference with his lawyers could well compel Mr. Allen to seek federal habeas relief under 28 U.S. 2241 in the form of an injunction. Were Mr. Allen, yes, I definitely read this. Like you guys are, but I do love it, so I'm happy to read it again. In the form of an injunction. Were Mr. Allen to prevail in that undertaking, a conditional writ of habeas corpus Though using more formal legal here, this is where we need a quick thing where because this is the punch. This is the punchline right here. Uh, Language would look something like, quote, "Release Mr. Allen," or "Leave his lawyers alone," end quote. I'm sure that's what y'all want me to read again because that's the money shot, right? That and as old as dirt. But win or lose, federal court is not a railroad siding Chief Justice Rush likely had in mind when she said at the hearing on the second original action involving this court in this case, quote, "My concern is getting the case back on track. Release Mr. Allen or leave his lawyers alone." All right. Yeah, that was worth you guys were right. That was worth reading again for sure. For sure. Um, yeah, y'all I'm coming with receipts on the fact that I definitely read both those footnotes. But that second footnote is tasty. Like that deserves a second reading, maybe even a third. Um, all right. What have we been running? About an hour and a half. Good. I guess Allie's not joining us. I think that pretty much gets us current. So right now, um, I think we're up to date on the filings. So she's got some motion still out there pending. Um, it's kind of par for the course, right? So I will I'm definitely going to be there on the 18th. Like I'm traveling down to Marion for a wrongful conviction case I'm working on, but I'll be back. I'll be there for certain. Um, and I just want to let you all know I love you guys. Thank you so much. It really, I had a tough week, and I have to say, I was looking forward to hanging with y'all. You guys make me feel good. So I love the community. I love my mods. You guys are the best. I thank all of you guys for that. All my mods in here, you guys are just the goods. I don't know what other way to put it. I mean, to dedicate your time and your effort and just out of the kindness of your heart um is really kind of hard to put into words how grateful I am for y'all. I'm gonna need the crying gum soon. I'm like an emotional mess right now. Also, you'll have to bear with me, man. But I do want to thank everybody. So I want to go through, give out some fam hugs because Allie's not here. I'm gonna get to do my hugs because the boss is upstairs. She might hear me though. I'll have to whisper. Jackie became a new member. Fam hug. Welcome to the fam, girl. Ellen Fagerland. Ooh, $20 holla. Boom. Thank you for being on Proof Podcast Sidebar. I loved it. I love Susan and Jacinda. They're awesome. I was excited when they called me and asked me to do it. I love, especially Susan's just a beast. Like she's another, I love me strong women lawyers, man. Y'all know that. So she's one of those. So yeah, no, thank you. Thank you for listening. And if y'all haven't checked it out, I did the sidebar with Susan and Jacinda. I think it dropped Thursday, on their second season, which is another great season. They're in there doing the work. So definitely check that out. And Jen, an always giver. And again, Ellen, you're an always giver too, because I've seen you in here. Jen, thank you so much. That's incredibly generous of you. I really, really appreciate it. And thank you for your kind thoughts. I appreciate that. Hater guy. Yes, habeas. I tried asking you why they don't file that on the last RA Live. Can they not do that now? Because motion to dismiss in a speedy trial violation. I mean, I think that that's at this point, it's a last resort. I mean, but it's almost getting to the point where maybe you have to do it. Like I'd be contemplating it just because they won't move him out of the damn prison. Like 3 times she's denied it when there's just a viable option that I just don't get me started. I just don't understand where she's at. mentally. Is this just like screw you guys for messing with me? I'm gonna try like this. It can't be about that. It's got to be about Richard Allen and his constitutional rights in the families of the victims. It's that's who this thing is about right now. Doesn't have jack shit to do with her. Like she's just supposed to be keeping this thing on track, ruling on motions, deciding what's going to be admissible, what's going to be inadmissible, and getting us to trial. That's her role right now. And she's fucking it up. Period. Um uh Nav the EO member for 3 months. Aw, big family hug, 3 months. You're an OG. I know this. And this is beyond like, I don't even know how much that cost, but I know it's a lot. So, and I know that you've done it before, and I'm beyond grateful to you. That is so incredibly generous, and I'm sure that the 50 people that were gifted memberships are also incredibly thank you so much for that, Nav. That's amazing. Thank you, man. That's just amazing. Um, uh, got a $2 holler. Appreciate you. You're an always Precosin is always an always giver, always giving the love. Appreciate you. I hope I read footnote 1 again. It's look, that I said it going in that entire motion is just money. It's a money motion. And I'm anxious to see is the state even going to respond? To me, the only response is for McClelland to tuck tail and say, "All right, I'm gonna withdraw that one. I'm gonna file it as a indirect criminal contempt under its own case number." He's gonna have to admit he was wrong, that he screwed it up, but it's his only route, I think. I don't know if he has another route other than that. Doesn't seem like it to me. So thank you for that $2 holla. Debbie, an always giver. Thank you so much for that $5 holla. Appreciate you. Angel Ray. Yes. Footnote 1. I got it. Footnote. You guys, I am like, as soon as I'm done with this live, I'm going back and watching the recording, and I'm going to post. I'm going to cut the little clips of me reading the footnotes initially and put it on Twitter. And then I'm going to go. Exactly. Son of a bitch. Yeah. So they gave me some good toys to play with, by the way. I've got fun things that I can use when people sass me. I could do things. Like when people do great. So that's for all this. So Mandy was taking sometimes I'll do voice chat or voice text to to her and Stevie. So she started recording them, which are pretty good. So this is one. What the fuck she's talking about? What the fuck is she talking about? I can't remember who I was talking about, but it might have been Coffin Never. It was somebody. It was some kind of nonsense that I didn't know what the fuck she was talking about. I know what the fuck she's talking about. What the fuck is she talking about? Exactly. All right. Okay, let's see where was I. I was at okay, Nurse Kins 67 76. Sorry about that. Bobby, can you please read footnote 1? Footnote 1. Yes. You guys were late. That's what it was. Y'all were late. That's what happened. I did not forget the footnote. Like I'm taking the now it's moved to the personal thing. Now I'm taking it to the personal attack that I forgot to read footnote 1. I clearly read it. Like, I can't believe there's not one, like, yeah, Bob, you definitely read it, like, in the chat. Like, I'm going to go look after I'm done. Joanne, Bob, footnote 1 on first document. Read it, please. Most important. Thanks, Bob. Thank you, Jedi. Appreciate you. Thanks for that $5 holla. Snarky Sass Angel, $5 holla. Read footnotes, please, Bob Mata. Oh, my God. $5 holla. Hopefully I made up for it. I reread them. So Precocent, $10 holla. Thank you, Stevie. Yes, Stevie. Stevie's my hero. And if y'all I'm assuming that y'all are putting Stevie's links to his YouTube. See, like, secretly, I don't want his shit to blow up because then I'll lose him. Like, he's my guy. Like, I don't know what I'd do without Stevie and Mandy, you know? Actually, I do want him to blow up. That's why I always promote his shit. So yeah, make sure if you're because he just dropped a an amazing, uh, video on Idaho 4. Like, if you wanna kinda know what's what, I would definitely go over there and check that video out. It's doing well for him, and it should because it's really well put together. So make sure you're going to check out Stevie's, channel, please. And thank you for that $10 holla. Sandy, aw, fam hug. It's like, you're an always giver too, and I adore you, and you're awesome in many, many ways because 'cause you're one of my mods, and so you're just an amazing person. So thank you, Sandy. Um, hey, where's Shelly? $2 holla. Appreciate you. Is the US Supreme Court aware of this case? No clue. No clue. I don't know, honestly. Probably not. Probably not. Not at this point. If he's convicted, I have a feeling they definitely will at some point. Like this shit show, whew, it's going up. It's going up there at some point if there's a conviction. Unless it doesn't even have to make it past the appellate court level, you know? I mean, they on direct appeal, they may be like, oh, that's structural error. We're gonna have to kick it back down. And hopefully Gull will be retired by that point. Thanks, Bob. Is this the verdict? Jedi? This is the verdict. And the verdict is you're awesome. Laura Smart, $20 holla. Oh, hey, Bob, have you spoken to the others about whether or not Gull usually acts like this on her other cases? I have spoken to people, and not like this. I mean, she runs a tight ship. Like she is a tight ship running judge. You know what I mean? The people that I've spoken to that try cases in front of her, she is not warm and fuzzy. Like as a general proposition, you know, she runs a tight ship, but I also have people sending me, the things that she does in other cases too. So she's certainly not infallible. She's made pretty massive mistakes on other cases as well. So I like, when you're on a case like this with this kind of scrutiny from the world, um, it's a lot. I would just think that's why I'm always trying to get in her head. Like I'm trying to think, all right, like what was she thinking on this one? I don't know. Isn't it at some point I still am like, why are you even dealing with this shit? You know, like you don't need to deal with this shit. Like you've been on the bench forever. Like just like recuse yourself. Like you're not gaining anything from this case. No one's gonna walk away from this case like saying, God damn, like Judge Gull, move over, Judge Newman. Judge Gull's the new one on the, Mount Rushmore of judges. It's not happening. It's like way too much water under the bridge at this point. It's like way, way, way beyond that. I just can't see what she's gaining from it. I don't know. It just seems spiteful to me. Maybe I'm wrong though. Um, RMR, $5 holla. Appreciate you, man. Thank you. Or gal, whatever your case may be. Hater guy, $2 holla. No hug from me, please. My condolences. All right, good. I didn't want to give you a hug anyway, hater guy. Thank you so much for that $2 holla, brother. Lead with love. $15 holla. Giving a little sympathy for the accused and his inability to even talk to anyone about this shit. For real. There's no question about that. Thank you for that $15 holla. Lead with love. And then Snarky Sass Angel, another $5 holla. Thank you. We love Matalata. And I love y'all back too. All right, y'all. I think that'll do it. So thank y'all for being here. We had a nice crew. I think we got over 800. And as always, I appreciate all of you. Make sure you're liking, subscribing, sharing. Like Jay's trying to catch me. Like he just crossed 13,000. I told you we're like two horses, two thoroughbreds racing. I took a little lead. He threw a couple more Adelsons out there. He's catching up. Come on, let's go. We could do it. Like we got to bring home the roses. Let's go. But in the meantime, if you're not sub to him, and his channel, and Shannon and Joe Jackalone and Publicly Buzzed and Stevie. And our newest is Missy Mayhem. Missy, now I don't know if Missy's on YouTube as well as Kick or just Kick, but find Missy. She's amazing. She's fam. So make sure, oh good, you threw her up in the chat. So make sure you guys are subbing to all my partners in crime, because I love them all dearly, and they all have great shows, and they're my favorites. So and thank you again, mods. I adore you. I know I thanked you already, but I'm thanking you again because I always forget to thank you. So I'm going to double thank you this time. So thank you guys so much. A couple things coming up. Really excited about next Friday, right before Alice and I go on Jam Cruise. I am conducting an interview that I am super excited about with the one and only incredible advocate, victim advocate, missing persons advocate. I'm so excited about Julie Murray is going to be joining me. So that's going to be amazing. She just dropped her pod, Media Pressure. The thing is insane. Oh, what's up, Teresa? I love you. I saw you earlier, and definitely sub to Teresa. I'm sorry I forgot you even, because you're definitely fam too, girl. So yeah, drop Teresa's in here too. She is fam. So yeah, Julie Murley, I'll get it out there. It's probably, I'm going to probably do it 6 my time, 7 her time. But she's got her pod out. It shot up to #1 on Apple Pods. So it's amazing. So that's going to be great. I should be doing an interview with Bill tonight. I'll drop that as a premiere on Monday, and I'm going to try to do a couple lives next week, y'all. In order to hang with y'all before we go on our little trip. And I'm excited. I'm looking forward to it. I'm going to because I'll be on, I'm legit going to get a vacation. I'm not going to be tweeting, because I'm going to be on a boat somewhere in the Caribbean, listening to all kinds of music for 4 days. I'm ready for it. I'm super excited. Boom. Exactly. Nailed it. All right. So thank y'all for hanging. I love you long time. And as you know, without y'all, I'd just be an old man talking about old and new and current cases. Nailed it.